Am I audible? Yes, sir, you are audible, sir. Ashish, sir. Very good afternoon. I cordially welcome all participants on behalf of Chebrol Hanamaya Institute of Pharmaceutical Sciences for today national webinar on intellectual property rights overview and recent trends. I cordially invite Mr. Ashish Sharma for today's webinar, and of course, thanks very much for accepting our invitation, sir. On behalf of Chebrol Annamaya Institute of Pharmaceutical Sciences, now I request our Principal, Dr. S. Vidyadhara, IP Education Division Chairman, to address the gathering and give welcome note on this August occasion. Thank you.
So, good afternoon to Dr. Pavan Kumar and the organizing committee. And we are overwhelming to invite today's chief guest, Sri Ashish Sharma ji, for this August occasion on the eve of World Intellectual Property Rights Week. This Chebrol Hanamaya Institute of Pharmaceutical Sciences, in association with Indian Pharmaceutical Association Education Division, IQAC of Chebrol Hanamaya Institute of Pharmaceutical Sciences, IIC of Chebrol Hanamaya Institute of Pharmaceutical Sciences, Department of Pharmacology, is cordially inviting Dr. Ashish Sharma ji for delivering the session on intellectual property, patent, and the Indian pharmaceutical industry scenario. And on this August occasion, I cordially invite all the delegates and all the participants, as well as our staff members and students, to take active role in listening and achieving some knowledge on the focus that is going to give by Ashish Sharma. So on this August occasion, I'd like to mention a brief note on what is patent. The Indian pharmaceutical industry is a successful high technology based industry that has witnessed consistent growth over the past 3 decades. The current industry players comprise several privately owned Indian pharma companies that have captured a substantial share in the domestic pharmaceutical market due to factors such as favorable government policies and limited competition from other countries. Factors such as protection of intellectual property are increasing in significance due to the growing recognition of the need of ensuring protection of valuable investments in research and development. Efforts are being made in India to curb problems of weak enforcement of existing intellectual property legislation, and the Indian government is moving towards establishment of a patent regime that is conducive to technological advances and is in keeping with its global commitments. With regard to pharmaceuticals, particularly we are dealing with pharma products and drugs and manufacturing. In case of substances intended for use or capable of being used as food, drugs or medicines, or substances produced by chemical process, patents are granted only for the process of manufacture of such substances, and not for the substances themselves. Hence, pharmaceutical products are currently not granted patents protection under Indian law. This again regulated by the federal regulatory authorities of Indian government as well as FDA of global market, that is United States of America. At present, India had a product patent regime for all inventions under the Patents and Designs Act 1911. However, in 1970, the government introduced the new Patents Act, which included pharmaceuticals and other products from eligibility for patent. Was introduced to break away India's dependence on import of bulk drugs and formulations and provide for development of self-reliant indigenous pharmaceutical industries to short the expenses that are going to render in this particular research and investigations. The establishment of World Trade Organization led to a tremendous paradigm shift in the world trade. The agreement on trade-related intellectual property rights was negotiated in the Uruguay, the trade nations of the General Agreement on Tariffs and Trade. And one of the primary reasons for incorporating intellectual property issues into the GATT framework was the pharmaceutical industry. India signed the GATT on 15th April 1994, thereby making it mandatory to comply with the requirements of GATT. Including the agreement on TRIPS, under the Patents Act 2005, patents will be granted both for products and processes for all the inventions in all fields of technology. This is a real move by the government of India under the TRIPS and GATT agreement. India is thereby required to meet the minimum standards under the TRIPS agreement in relation to patents and the pharmaceutical industry. India's patent legislation must now include provisions for availability of patent for both pharmaceutical products and processes inventions. Patents are to be granted for a minimum term of 20 years to any invention of a pharmaceutical product or process that fulfills established criteria. With this brief introduction about the patents and Indian pharma perspectives, particularly related to the pharma product patents and process, I once again thank our chief guest, Dr. Ashish Sharma ji, for immediately accepting our invitation and going to deliver a talk on this very apt topic that present day need for all the pharma researchers and students. I cordially welcome you, sir, on behalf of Jabrul Hanuman Institute of Pharmaceutical Science, and definitely with your valuable and expertise talk, our students, our staff members, and every one of us will definitely get benefit out of you. And we hope that your talk will be very useful for us, sir. Most welcome you, sir. Thank you for being with us, sir. Thank you.
Thank you, sir. So nice of you, all the management staff and all the faculty members who has organized this beautiful event. Because on the occasion of World IP Day on 26th April, I am happy to be present here today to celebrate the event with you. Let me extend a hearty congratulations to all of you. And because India over millennia always encouraged creativity and innovation with its own system of fostering creativity. One of the most effective ways of demystifying IP and to reach out to people is through universities and other educational institutions. Friends, today we are living in the era of information revolution. Intellectual property is the result of conversion of knowledge into a commercially exploited potential. It is for the betterment of all nations that we promote intellectual property rights. Only societies where such rights are protected witness culture advancement and economic progress. Universities are and academic institutions are academic communities organic link with the societies. Promoting IP education in the academic institution is crucial to promoting IP in the society, because the future clearly belongs to innovate societies. You as a teacher shapes destination in your classrooms. Teaching of IP will be a new tool in your hands to contribute to our civilization's onward journey. The number of patents filing, you will be really surprisingly, the number of patent filing increased from 42,763 in 2014 to 15, and recently it was 66,440 in 2021 to 22. Further, India granted 30,074 4 patents in 2021 to 22 as compared to 5,978 in 2014 to 15. There has also been a reduction in the time of patent examination from 72 months in 2016 to 5 to 23 months of presents. For the first time in last 11 years, the number of domestic patent filing has surpassed the number of international patent filing at Indian Patent Office in January to March 2022 quarter. Of the total 19,796 patent applications filed, 10,706 were filed by Indian applicants and 9,090 by non-applicants. So these are some data which belongs to the Indian patent system or filing. Now I would like to share my presentation. So could I? So the overview of intellectual property rights and what are the recent trends I will discuss here. Am I audible, Dr. Vidya?
Sir, audible, sir.
Okay. Okay. So basically, what is the intellectual property? First of all, you will have to know what is the intellectual property. Intellectual property is the property intrinsically intangible developed due to creation of mind and gives the property owner similar rights as in relation with tangible property. Like it can be an expression of an idea or invention, expressions of literary collection, unique name or trade name, industrial designs as they appeals to the eye, new plant varieties, cinematographic, dramatic performance, musical works, etc. So intellectual properties is the type of the intangible property in the terms of expressions of an idea, inventions, trade name, industrial designs, new plant variety, or cinematographic work or literary work. So how the invention born? Because of thinking, self-interrogation, ask yourself. So there should be some questions: how, why, what, when, where. So because the necessity is the mother of invention. If you have a problem, you will have to find the solution. So this problem solution approach goes to the invention. So protection of idea, first of all, if you have an idea, so it should be conceptualization or exploration, adaptation, implementation, industrializations, marketing, selling, economic returns. So all the things goes to the IP, belongs to the IP. Here you can see the one product, and it is cellular phone or mobile phone. So there are multiple IP rights involved in this cell phone. The trade name is a Nokia, or product name is 208 startup tones. So these IP rights can be protected under trademarks. And what can be covered under copyright? Because I will discuss here also the difference of various IP rights. So softwares, user manuals, ringtones, startup tones, images can be covered under copyright. And patents and utility models, data processing methods, operating systems, operation of user interface. So these features can be protected under patents. And designs, form of overall font, alignment and shape of buttons, position and shape of screens. So these features can be protected under design registration. Here you can see in a single product, there are multiple IP rights involved. So these are the type of intellectual properties: patent, trademark, copyright, designs, geographical indications, plant varieties, semiconductor designs. First of all, Indian acts relating to IPR. The Patent Act came into force 1970. It was last amended in 2005. The Trademark Act 1999, the Design Act 2000, Geographical Indications of Goods 1999, the Copyright Act 1957, Protection of Plant Varieties Farmers' Right 2001, the Semiconductor Integrated Circuit Layout Design 2000, and Biological Diversity Act 2002. So these acts relating to the IPR. Here there is a difference. Between various IP laws. What can be covered under patent? Invention can be protected under patent. Invention means the new process or a new product. And what are the trademarks? Words, phrase, logo used as a trademark on a goods or as services can be protected under trademarks. Original literary, dramatic work, musical and artistic work, cinematograph, films, sound recordings can be protected under copyright. Geographical indications, identifications of goods or services from a geographical sources of origin. Designs, shape configurations, pattern, ornamental, applied to article and judged by looks or appeals to the eye. How to protect? Patent can be protected file the application for a grant in patent office, and trademark for a file the application of a registration of trademark in trademark registry, file the application for registration of copyright to the copyright registry. Geographical indications related to the particular geographical regions like Mysore silk, Darjeeling tea, Bikaneri bhujia. So these are related to the geographical indications. Designs, file application for registration of design with an Indian Patent Design Office. Who can apply for registration? For a patent, inventor or assignee can file the patent application. User or proprietor or owner can file the trademark applications. First, author or assignee can file the copyright application. Sorry. Association of persons or producers can file the geographical indications. Proprietor of new or original design not previously published, so who can file the design application. And what are the tests for protection? Patent, for patent, there should be novelty, inventive step, and utility, means it should be having economic significance. And for a trademark, distinctiveness and use base. For a copyright, it should be original based, and source of a geographical origin for a geographical indications, and for design, it should be new and original. So term of protection. What are the term of protection? 20 years from the date of the filing, 10 years from the date of filing and renewable indefinitely for trademark, 60 years after the death of the author for a copyright, 10 years initially and renewable indefinitely for geographical indications, 10 years initially extendable by 5 years for a design. Right to exclude others from making, using, selling, offering to sell and importing gives the right from patent. Trademark gives the right to exclude other whose use may cause confusion or deception. Copyright gives the right to prevent unauthorized copying or public performance. Geographical indications rights gives to the exclusive right to the use of the GI in relation of those goods. And design rights power to exclude others to use or apply registered design. So these are the organization structure of intellectual properties office. There are 4 patent offices in India: Delhi, Mumbai, Chennai, and Calcutta. And there are 5 trademark offices: Delhi, Mumbai, Chennai, Calcutta, and Ahmedabad. And design office is the head office in Calcutta, and geographical indications in Chennai. Registrar of copyrights is in Delhi. So the patent system, what is a patent? So patent gives the exclusive right to the patentee of a product or process to prevent third parties who do not have his consent from making, using, offering for sale, selling or importing for those purposes that product or the products produced by patented process. So patent is a basically monopoly right or exclusive right. So sometimes it may call the adverse negative rights, because patent creates the monopoly, and monopoly kills the competition, and killing competition hampers economic growth. Therefore, patent should not be granted. Is it? No, because it is benefit to the public. What benefit to the public? Motivation to research and inventions, provides incentive to inventor to disclose his invention to the general public instead of keeping it a trade secret, commercial reward for converting inventive ideas into a vendable useful products, provide incentive to invest capital to develop new products. So these are some benefits of the patenting system. So there are 3 criteria for getting the patent. The invention must be passed 3 criteria: novelty, non-obviousness, and industrial utility. Novelty means the invention should be novel throughout the world, not only in India, not only in particular territory. Because if whatever which is available in the public domain before the date of the filing, everything is under prior art. So it should be novel. And non-obviousness means it should having technical advancement, and industrial utility means it should having some economic significance. So these 3 are the patent criteria. So what does the description contain? Here you can see the teapot with 1 spout. Okay, so it was a prior art teapot with a 1 spout. And what are the drawbacks of this prior art? Time, it was a time consuming. So one of the inventor has added 2nd spout in this teapot. So reduced the filling time for multiple cups. So time will be half. And solution provider provide a 2nd spout. Advantage of the invention, filling time is reduced. So you can see the both pictures, before prior art and the invention. So sometime, if your invention passed the test of novelty, inventive step, and economic significance, however, the patent office may refuse your application on this ground, which are mentioned in the section 3 of the Indian Patent Act. Which are the grounds? An invention which is frivolous or which claims anything obviously contrary to well-established natural laws. If your invention relates to the contrary to well-established natural laws, your invention will be not patentable subject matter. And an invention, the primary or intended use or commercially exploitation of which could be contrary to public order or morality, or which causes serious prejudice to human, animal or plant life or health or to the environment, means the invention which is intended use or commercially exploitation which could be contrary to public order. Like you can take the example of a COVID-19 virus, SARS-CoV virus. You can take the example. If this virus is novel and it may having a technical advancement also, and economic significance may be there, but because it is a contrary to public order or morality, against the morality, but it will be not patented subject matter. The mere discovery of a scientific principle or the formulation of an abstract theory or discovery of any living thing or non-living substance occurring in nature. There is a difference between discovery and invention. Discovery means which is already existed in the domain or in the nature, which is discovered, not invented. Invented means the thing which is not existed prior and which is created by human being. So it is an invention. And the mere discovery of a new form or substance which does not result in the enhancement of a known efficacy of that substance or the mere discovery of a new property or new use of a known process, machine or apparatus unless such known process result in a new product or employees. Means it is a very important section for a pharmaceutical purpose. You can see for the purpose of this clause, salts, esters, ethers, polymorphs, metabolites, pure form, particle size, isomers, mixtures of isomers, complexes, combinations, and other derivatives of a known substance shall be considered to be the same substance unless they differ significantly in properties with regard to the efficacy. If already having a drug in a meta position, and if you replace the position in an ortho or a para position, and if you claim claim your invention is new, no, it will be obvious because it's only changes of positions. Yes, if you have any significant efficacy, enhancement of efficacy, yes, you can take the patent on your invention. A substance obtained by a mere admixture resulting only in the aggregation of the properties of the components thereof or a process for producing such substance, the mere arrangement or rearrangement or duplication of known devices, each functioning independently of one another in known way. A method of agriculture or horticulture, any process for the medicinal, surgical, curative, prophylactic, diagnostic, therapeutic, or other treatment of human being, or any process for a similar treatment of animals to render them free to disease or to increase their economic value or that of their products. So plants, process, or diagnostic method, method of treatment, surgical methods are not patentable subject matter. Plants and animals in whole or any part, a mathematical or business method, or a computer program per se, or algorithm, a literary, dramatic, musical, artistic work, or any other aesthetic creation whatsoever, including cinematographic works and television products, are not patentable. A mere scheme or a rule or a method or a performing mental act or a method of playing game, a representation of information, topography of an integrated circuits, an invention which in effect is traditional knowledge or which is an aggregation or duplication of a known device. So the traditional knowledge or knowledge in the Ayurveda already existed cannot be claimed as it is patent. Yes, if you have developed a new formulation of any herbal formulation or any Ayurvedic drug, you can claim that your invention has some therapeutic effect and in consideration to comparison to the already existed formulation. Yes, who can file the patent application? Application may be made by the first inventor either alone or jointly with another, or is there assignee legal representative of the inventor or assignee. So these are the contents of the patent applications: title of the application, field of the invention, background of the invention, summary of the invention, detailed description, claims, drawings, abstract. Statutory fees 1,600 for natural person, startup and educational institutions, 8,000 rupees for other than natural persons, startup and educational institutions. After 30 sheets, 160 rupees per sheets will be additional cost, and 800 rupees for other than natural, 320 for claims, and 1,600 for other than natural per claim. How to file a patent application? Documents can be submitted in patent office through online, through post, or can be submitted by hand. General procedure for obtaining a patent. So these are some important aspects. Filing of patent application. After the filing of patent application, patent office will publish your application in their gazette. And if you want to publish your application early, you can give the request for early publication. And after the publication, any person can file the pre-grant opposition. And after the publication, the next step is the examination. Request for examination means if you file the patent application, you will have to file Form 18. It is called request for examination. Otherwise, your patent application will not be examined, and within 48 months, if you don't file the request for examination, your patent application will be lapsed. And after the filing request for examination, patent office will publish, patent office will examine this application and will convey the objections to the applicant, and applicant has to file all the reply and objection complied within a 6 months. And after the submission of reply, the patent office will consider your reply. If it is satisfactory, then the patent will be granted. Otherwise, the hearing will be given to you and the applicant may defend in the hearing your invention is patentable. If the patent office will satisfy, then they will grant the patent. Otherwise, they will refuse the application. And these are the documents required for filing a patent application: covering letter, application for grant of the patent, complete specification, statement undertaking, power of attorney, if you file through attorney, declaration of inventorship, certified true copy of the priority documents. If you filed some in other countries, so you have to file the priority documents in India and requisite statutory fees. So there are two types of specifications. One is provisional, second is non-provisional, or you can say complete. If you have some idea in your mind, but you not finished the experimental work or not fine-tuned your invention, so you can file the provisional specification to protect your priority, because there is a first to file system. If you don't first to file, so it may chance that somebody may file your application before your filing, and the patent rights will go to him. And if you the provisional, after the provisional, you have to file, the applicant has to file complete specification within 12 months from the date of provisional. If you don't file the complete specification, your application will be lapsed or abandoned. So these are the contents of provisional. Claims and abstract are not a part of provisional. If you not finalize the invention, you can give only the format or some concept in your provisional specification, and fee is the same for a complete and provisional. Compared with the provisional, the complete specification shall contain the full description of the invention and its operations, methodology, working examples, the best method of working, and with a claim or claims, important component in the complete patent specification. It is the legal operative part which define and determine the legal protection sought for. The claims. Claims are the legal boundaries of your invention, be accompanied by any abstract to provide technical information on the invention. Important aspect of the Patent Act: publication, examination, pre-grant opposition, post-grant opposition, revocation of patent, and compulsory license. So I already discussed, after the filing, patent office will application automatically after 18 months. But if you want to file early publish, you can give the separate request for early publication. The patent office will publish your application within a month. These are the particulars of the publication: number of application, date of filing and abstract, international filing date, name and address of the applicant. So these are the contents. After the publication, patent office will examine your examination, your application. If you file the request for examination, if you don't file the request for examination, your application will be lapsed or treated abandoned. So it is a very important aspect for pharma persons. Section 84 of the Indian Patent Act describes the compulsory licenses. At any time after the expiration of 3 years from the date of the grant of a patent, any person interested may make an application to the controller for grant of a compulsory license on patent on any of the grounds, namely the reasonable requirement of the public with respect to the patented invention have not been satisfied. The patented invention is not available to the public at a reasonable affordable price. The patented invention is not worked in the territory of India. So there is an example relating to compulsory license. India's first ever compulsory license was granted by the Patent Office on March 9, 2012 to Natco Pharma for the generic production of Bayer Corporation Nexavar. You definitely heard about Nexavar, a life-saving medicines used for treating liver and kidney cancer. So Bayer sold this drug at exorbitant rates with 1 month's worth of doses costing around rupees 2.8 lakh. But the Natco Pharma offered to sell it around for rupees 9,000. You can see the huge difference, 2.8 to 2,80,000 per month package sold the buyer, and Natco offers for rupees 9,000 for a month, making it affordable for the people belonging to every stratum. So all the three conditions of Section 84 were fulfilled, and the decision was taken for the benefit to the general public. So patents rights are very useful to the public. After the grant of patent, patentee has to pay the renewal fees or annuity fees till the term of patent, that is 20 years. If patentee does not file the renewal fee, so the patent will be expired and it will be covered in the public domain. So this is the fee up to 6 years. First 2 years are are exempted for a fee, and from 3rd to 6th year it is 800 per year, 4,000 per year for other than natural, 7 to 10 years 2,400 per year for natural person, for startup, for education institutions, for 12,000 per year for other than natural, for 11 to 15 years 4,800 per year, 16 to 20 years 8,000 per year. Searching for patents can be easy, but some basic knowledge should be needed, because if you see sorry, if you see, it is general spring, but in the patent term it may called the energy storing means. It is a transistor, but in the patenting term it may call semiconductor switching device with a control electrode. It is a simple toy ball, but in the patenting term, spherical object with a floppy filament. Examples are there. You can see this is a cat's eye. Software breakthrough inventions. IBM got the patent on fat lines to turn a thin line on a computer screen into a broad line. Microsoft got the patent on page up, page down for a double clicking. Apple for a automatic software update, flight to unlock. Intel digital video recording, pop-up windows. Alcatel-Lucent MP3 technology. Sumasundaram Ramkumar got the patent, who's the Indian inventor or Indian applicant for a dual SIM phone. You can see some very basic example of the patent which was granted earlier. This is mustache guard. So what is the traditional symbol of a true gentleman if not his mustache? This mustache guard, patented by V.A. Gates in 1876, is a witty solution to protect your mustache and your reputation. During the holidays feast, a curved and concave shield, which may be made of vulcanized rubber, metal, or any other suitable material, promises to keep your mustache out of harm's way. Overindulging this holiday season, cheers to innovations. So this is a bicycle. This bicycle, patented by Louis Burbank in 1900, allows you to exercise both your legs and arms while cycling. The object of the invention is to provide means whereby one may enjoy with a bicycle exercise like that of rowing with a pairs of sculls. The patent explains looks fun, but we are not sure how the brakes work. Traffic signals, radio, paper clips. Yes, it is very important invention. If you unfold this clip, paper clip, so it is a simple piece of wire, nothing else. But it was a patented subject because it changed the entire utility. Alarm clock, sewing machines, camera and stumps, refrigerators, locks, guns and pistols, pressure cookers, refrigerator, typewriter, washing machines. So this is the patent certificate. After the granting, this type of it is over now. Am I audible?
Yes, sir, you're audible.
Yeah, please. The questions may ask you, please. The audience can ask the question to me directly.
Sir, with your permission, shall we conclude, sir?
Yeah.
Yeah. So thanks, Shri Ashish Sharma ji, for sharing your valuable views and concepts in intellectual property. Promisingly, it would be a great added advantage for career of our participants. So thanks for giving your valuable time for us. And at last, on behalf of Chabrul Anumaya Institute of Pharmaceutical Sciences, I thank organizing committee and every participant for their contribution. With these remarks, we conclude, sir.
Thank you, sir. Thank you.
Thank you. Thanks once again, sir.